right, we are on the record in 462-464, the Gibb matter. Mr. Willick, are you there?
I am, Your Honor. Marshall Willick, 2515, for Farrah Kaufman, who is also online. With me is Richard Crane, bar number 9536.
And I can see Mr. Crane, but I cannot see you, just so you know. Mr. Gabato, your appearance?
Good morning, Your Honor. Alex Gabato, 10592, on behalf of Chris Gibb, who is present.
Thank you. We are on today on plaintiff's motion, which I have reviewed. I've reviewed the response that was filed by the defendant. I reviewed the reply. I know there was a supplement that came in recently. I also saw that we got an order from the Supreme Court dismissing the appeal, so the jurisdictional questions, I guess, don't exist anymore with regard to those issues. So, Mr. Willick, what else do I need to know?
Well, Your Honor, I guess I'll start. The reason there's two of us on, I was going to address timing and related issues relating to the motion that we filed. Mr. Crane is present to explain technical questions that have come up during the briefing relating to procedure at DFAS and the timing of making applications there, because he does most of that work through the Quadramasters division. I know that you've presumably read the materials, but because there was a flurry of back and forth, I would like to go back over it unless the court says that you don't need any further information.
Well, certainly it's up to you. If you think there's something you'd like to highlight, I certainly don't want to stop you from doing that.
All right, then let me briefly go through it.
Before you begin, real quick, I'm having really bad feedback loop on my audio, so I'm having a hard time hearing this. If the court can just give me a moment to log out, log back in real quick, see if that clears it up.
Certainly, go ahead.
Because it's really bad. Just give me 1 minute.
Hey, Alex, before you do that, my only other suggestion would be that everybody else who isn't speaking, if they mute, then it sometimes clears up the feedback.
Yeah, everybody else is muted.
It looks like everybody's muted. It's just, I don't know, I think it's my device, so let me just unplug it and plug everything back in. I'll be back on in a minute.
Okay.
Thank you. Didn't help it. I'll do my best to listen, Your Honor. I apologize.
All right, not a problem. All right, Mr. Willick, go right ahead.
Thank you, Your Honor. There are two supplements that were filed on August 31, 2020. They were not invited by the court. They were intended for a hearing that had already passed and an order that had already been issued. So our first point is that they were fugitive filings. They relate to no active motion or counter motion before the court and therefore aren't actually supplements. Second, they were filed after a notice of appeal was filed. As the court noted, I'm not sure that the court's observation about the effect of the dismissal is correct. The notice of appeal was filed August 28th, which divested the court of any jurisdiction to entertain them or otherwise act on them. I'm not sure that a dismissal of that appeal at a date subsequent to that acts retroactively to resurrect the propriety of the original filing.
Just so I can clarify, my indication was that my jurisdiction is restored for today's hearing, certainly not talking about what happened from a retroactive standpoint.
I'm sorry if I misunderstood. Our third point on the filings is that they seek to actively distort the record because the attorneys have significantly misrepresented what the documents actually say and mean. We filed our motion to strike on September 4. No opposition was filed until September 28. It was due no later than September 18. The late filing is enough on its own to strike the opposition, but in addition to being untimely, it included a counter motion to set aside the OID. Now again, the counter motion was improper as the court lacked jurisdiction to act on the date that it was filed as an appeal was pending. The ultimate withdrawal of the appeal didn't cure the pre-existing jurisdictional defect. Any motion to set aside the OID couldn't be filed until after October 7, when the Supreme Court dismissed the appeal. But we believe the court should strike all of the filings that occurred during the pendency of the appeal except those relating to a collateral issue, which would be our motion for fees. In the larger picture, even if this court wanted to overlook questions of jurisdiction and the procedural and timeliness errors, the counter motion, we believe, should be denied. His basic complaint is bogus. His complaint was that FARA stalled the insurance. After we got his filing, we did an investigation, and we've confirmed that FARA contacted the insurance company right after the hearing. I actually have the physical call logs proving it. The insurance agent claims that Kristen refused to take their calls. In other words, he produced his own problem.
Your Honor, I object. Mr. Willick does this often. This is the first time I'm hearing of any of this nonsense. How can we possibly be allowed to respond to being called liars to our face and bringing up information from people that they could have brought this up right away? They could have put this in the pleadings right away so that we can address it. But this happens all the time with Mr. Willick. It happened the first time, which is the reason why we had to kick the hearing for another day to review a case that he cited out of nowhere. It's just unfair. It violates due process. I don't think that this is something that Mr. Willick should be allowed to argue at this point. At least not without putting it on paper and allowing us to respond. And at this point, we don't have time to do that.
Well, and certainly I understand that, but this is argument. The court understands that that there's potential, that we haven't demonstrated it, but certainly it's argument. So, Mr. Willick, go ahead.
Thank you. As to remedies, had Christian cooperated at any time in the last 5 to 10 years, he would have had an appellate remedy. He did file a notice of appeal. It's his fault that he forced this to the last possible minute, making his own appeal logistically impossible. He created this problem, and the court resolved it. He is in no position to complain about it. Now, as to our counter motion, this court ordered that the SVP was to be awarded to FARA if Kristen didn't comply by actually having the insurance alternative in place before his retirement. That's the order from August 27. He did not comply. The order incident to decree was filed on Friday, August 28th at 2:55 p.m. That is after hours at 5:55 p.m. on the East Coast, where DFAS is located. They are closed on Saturday and Sunday. Kristen was scheduled to retire on Tuesday, September 1. That left us one day, Monday, August 31, to make sure that the SVP was in place or it would be lost to FARA forever. In other words, this was the last possible moment to file the OID that included the provision for the SVP to be in effect. On that last day, August 31st, at 11:06 a.m., which is 2:06 p.m. East Coast time, Mr. Gabato sent an email proclaiming, quote, "Good news, the life insurance policy for your client has been approved." That was a false assertion. What he actually included with that email was an indication that Kristen had unilaterally partially modified the beneficiary designation for an existing USAA policy he's owned since 2018 for his current wife, which he had not previously declared even existed, to give FARA a 31% interest in that policy. The policy document, which we burrowed down to, was for $650,000, making FARA's share $201,500 should Christian die. That wasn't even 25% of the necessary coverage. And it was entirely illusory because he could just as easily change the beneficiary, dropping FARA the very next day. So in no way did anything connected with Mr. Gabato's email comply with this court's order that he cooperate in FARA obtaining a life insurance policy on his life. We responded promptly at 1:22 p.m. That's 4:22 p.m. East Coast time, explaining all of this to Mr. Gabato. Hours later, at 3:34 p.m., which is 6:34 p.m. East Coast time, over an hour and a half after DFAS had already closed, we got another email from Mr. Gabato. As of the moment that email was received, Kristen was effectively retired, as nothing could be done after 5 o'clock p.m. on his last day of service. His active duty was over at that time, and he was actually retired as of midnight. The after-hours email indicated that there could be pending a 10-year term policy for $1 million. Of course, 10 years is only 1/4 of the time period that's required to be secured, because she has a 40-year life expectancy. And when we dug into it, we discovered just how duplicitous Kristen was even in that effort. For example, even though he's been a non-smoker his entire life, he told the insurance company he was a smoker to drive the premium cost up, figuring that the court, pursuant to Judge Duckworth's order some years ago, would make Farrah pay for it. It indicated a premium of $268.84 a month. That's nearly twice what Kristen was already paying for the USAA policy for his current spouse, because he didn't lie to the insurance company when he applied for that insurance. But the main point is that by the time he indicated that even this partial, overly expensive, and inadequate policy was available, DFAS was already closed, and the court's time period had already expired. I would like Mr. Crane to address the timeliness issues relating to applications at DFAS, since he does this literally every day.
I object to that, Your Honor. I should be dealing with one lawyer, not a gaggle of them. I shouldn't be dealing with 2 lawyers and 3 staff members and all their various inputs. If Mr. Willick has this case, it's his case. He should know the facts. He should be prepared to argue it.
I don't know that I'm clear on why I need to deal with the timing issues. Is this on the response to the counter motion, Mr. Willick?
Well, there was an excuse offered by and a further exhibit in the form of a letter from Mr. Gabato indicating that, gee, the time hasn't really expired, and that's simply a false representation. We were going to explain under the regulations what is actually available and when at DFAS. If the court doesn't want to hear about any of that, then I guess I don't have to go into it. But I always like to address the assertions made by our opponents. Now, as to who does it, there is no one attorney rule. The court has the ability to monitor its courtroom any way it wants. If you want me to say things that he's more qualified to explain, I can. If the court doesn't want to hear about it at all, okay. But we thought, for the purpose of completeness, for all the assertions made by both sides, that the court would want to hear about it and would want to hear about it from the person best able to explain it, because he does it every day.
Well, and as I recall, this was a question I had in the August hearing, the August 27th hearing, and I think you explained to me your position, and Mr. Gabato wanted an opportunity to be able to verify what you indicated, so I gave him that opportunity, and given the fact that we're down the road to this point, I'm presuming that what you told me back on August 27th is correct, unless you're telling me now that there's something different.
No, there's nothing different. There is simply, and look, I can make it a quick 10-second explanation. The military has a little codicil in their regs saying that you have to have the beneficiary designation in before retirement. That's absolutely what I told you, and that's absolutely true. Mr. Gabato has come back saying it's not too late to set it aside, and that's true under a different regulation. If I had given the military, say, a fraudulent order, if that hadn't been your real order, he has 30 days within which to show the military that the order that we provided had been superseded, expired, set aside, overturned on appeal, whatever. And if he could do that within 30 days, saying that it wasn't an authentic, valid order, then they would set the matter aside. That has nothing to do with what I told you. The expiration for her to get the SPP absolutely expired at 5 o'clock on August 31. No ifs, no ands, no buts, no exceptions, no nothing. Okay. And we did not submit a fraudulent order. It was your order that you signed. Since then, I think we found a typo in it, but it is your order, and it is the last order, and it is the authentic order. So there really wasn't anything that is relevant about Mr. Gabato's letter from DFAS saying that if it had been a fraudulent order, they would set aside the beneficiary designation. It is not an invitation for further litigation. It isn't an invitation to change the existing orders. It is an escape valve in case somebody submits a false order. And we didn't. So it's not really relevant to anything we did.
All right.
And I'll just wrap up at this point. We've given you a comparison chart to just summarize the bullet points of what I've already repeated here in court.
Can I object to that, Your Honor? And the objection is based on Mr. Willick's argument. Mr. Willick wants to argue that supplements cannot be filed after briefing is complete. And then what does he do? He goes and files a supplemental briefing, a supplemental exhibit when briefing is concluded the day before the hearing. So if his argument, if he wants to put on a motion saying that the supplemental exhibit that we filed is incorrect, he can't then do the same exact thing and insist on it being heard.
Well,
without destroying his own motion, without undermining his own position.
Well, that's not true, and I'd like to explain why.
Absolutely.
This is an in-court demonstrative.
Representative EDCR, the rule too, by the way.
I'm quite intimately familiar with it. This is an in-court demonstrative, which merely summarizes the documents the court already has. It is not in any way an exhibit asking for relief of any sort. It is only a summary. If we had been in a courtroom, what I would do is walk up to the
briefing done the day before that does not give us the opportunity to respond.
Just like you're in the courtroom, you don't get to interrupt each other. Certainly, Mr. Gabato, I'm going to give you an opportunity to argue that the supplement is inappropriate, just like I allowed Mr. Willick to argue that your supplement was inappropriate. But certainly, we don't interrupt the counsel while we're arguing.
My apologies, Your Honor. I apologize, Mr. Willick.
It isn't a supplement requesting relief. It is a demonstrative which summarizes filings that have already been made so the court doesn't have to dig through them. It can be regarded, it can be disregarded, it won't affect the argument. It's merely there for the court's convenience. If we were in a courtroom, it would be considered a demonstrative. When we inquired of court staff the court's preference for demonstratives that otherwise would be handed to the bench in an in-court proceeding, and asked whether it would be more appropriate to use screen share to put it up as a demonstrative, or it would be more appropriate to somehow submit it in advance, we were directed to submit it in advance, and it would be treated as a demonstrative as if we were in a courtroom. If that direction was incorrect, then I apologize, but we did ask that question, because if we were in a courtroom, I would have simply handed it to the court. I have been doing that in hearings for 40 years. Without anybody ever objecting to the use of a demonstrative exhibit. The technology makes it a little bit more challenging, but we did it this way because this is the way court staff directed us to do it. Just to finish, and then I'll be done. The proffered policies were all inadequate for various reasons, which I've already explained. FARA has a 40-year life expectancy and needs to be covered for that entire period. Nothing they have offered would do that. And creating an expense where none is necessary is, frankly, just dumb. We have complete coverage at this point for both the former spouse and the current spouse, appropriate for their varying levels of interest in the underlying retirement benefits. A 10-year term policy is irrelevant for any purpose. And it's worth repeating that this entire problem was brought on by Kristen refusing to cooperate in obtaining legitimate policy of insurance as ordered for most of the past decade. His attorney, Ms. Kramer, misrepresented the SBP to Judge Duckworth, claiming it was too expensive. But it's actually free under these facts. And neither Kristen nor Farah should ever have to pay a premium to keep it in force, because at the moment her eligibility is suspended because of her remarriage. But should he die, all she has to do is terminate that marriage and she immediately becomes re-eligible without premiums ever having been paid. Then she is eligible for the benefit and is free to remarry as she wishes. Kristen, at this point in proceedings, should not be rewarded for either his bad behavior for the last decade or for making false representations to multiple judges over the period of the last 10 years. And actually, things worked out, harrowingly, exactly the way that most benefits both parties. There is no better result possible, economically or otherwise, for everyone involved in this case. The final point to be considered for this hearing is the one that was the substance of our counter-motion, which is fees. The court has twice deferred the question of fees. It's time that Kristen paid for the huge amount of fees incurred for his many frivolous and bogus claims over the years, including for the last several months during this litigation. His refusal to cooperate in obtaining the life insurance went on for over 5 years. His latest claim that the statute of limitations somehow divested FARA of her share of the pension benefits was without merit and done without research. His attorneys repeatedly claimed that they hadn't done the basic legal research as to how the military retirement system works, even when we told them exactly where that information could be located and offered to supply it to them. And they've had months, and they still didn't read it or review it, or they did, and they simply didn't like what they found. Either way, they have caused an enormous expenditure of time and effort and expense without cause. If they had simply done the legal research they did, honored the court orders that had previously been entered, and otherwise behaved honorably, most of the expenses for these proceedings wouldn't have occurred. But they didn't, and those expenses did get incurred. The recent antics, filing a notice of appeal, filing fugitive documents, asking the court to rehear the entirety of the case, only further magnified the expenditure on our side. So we asked this court to allow us to submit a memorandum of fees and costs, and we're going to ask for an award of 100% of the costs FARA has incurred since hiring our firm, all of which was necessary to prevent her from being permanently cheated by Kristen, which he has relentlessly attempted to accomplish throughout this litigation. I rest.
Thank you. Mr. Gabato.
So let me start, Your Honor, with the assertion that she's not entitled to the SVP to begin with, according to the Henson case. So I'll cite it in full, and it's in the briefing on page 17 of 22. Henson v. Henson, 334, P3rd, 933, and 937. Specifically barred. It specifically bars what they are trying to do in this case. This SVP was never negotiated. The decree of divorce does not mention it at all. At a subsequent period of time, she decided, I want it, and brought it before the court. The court made the decision it made. FARA, the plaintiff here, she wants it her way. She wants to have her insurance agent. She wants to have her amount. She wants everything under her control. But she expects what? Chris to come to her and initiate everything? How's that supposed to happen? It could have been very easily accomplished to get life insurance at any time if Chris would have been able to do that. But that's not what they want. They want their insurance agent to do it in their way with everything that they want. That requires her initiation. It requires her to start that process. And she didn't start that process until this year, Your Honor. And then she started it by sending a letter to Chris directly rather than his attorney was representing him, which ate up more time. And then we had a hearing, and he brings up a case, and he misrepresents that case, which causes another delay. We have to have another hearing. From that point on, Your Honor, we've been very detailed in all of our efforts to accomplish what this court actually ordered. And what did this court actually order? That he cooperate in obtaining the life insurance policy. Not that it be obtained, that he cooperate, that he actually help out in obtaining it. And that's exactly what we did. I was proactive in constantly communicating with Mr. Willick and actually even asking for a hearing to clarify matters. He was proactive in chasing down this negligent insurance agent. And the result was that she got her insurance policy. Of course, she's not happy. It's not enough. It's too expensive. It's too short. It's this. It's that. It's never enough. It's never enough for Mr. Willick because Mr. Willick always wants a billing opportunity is what it really is. But the reality is that he cooperated. He did exactly what this court said. And at the last hearing prior to the entry of the OID, the court specifically said if he gets that insurance before the first, his wife keeps it. That is what happened, Your Honor. That's exactly what happened. There is no reason at this point whatsoever to grant the SPP to her. First of all, it's barred by law. Can't do it. Secondly, he complied with the orders completely, to the letter, both of us, proactively, working together to try to get as much information to these people to satisfy them, and we did. They said that he owes for TSP. Oh, there's no TSP. He said that the life insurance. Oh, guess what? He already got life insurance. Everything that he was asked to do, he's done. But now here we are asking for $16,000 in fees and this and that and the other thing for what? Because it wasn't enough. At the end of the day, it's never enough. But the point is that she's the one that waited first, 3 years after the divorce, to go to court to obtain an order on the SPP. Once the order was made by Judge Duckworth, then she should have started that process like she did now with her insurance agent, contacting Chris and trying to get the process started. She didn't do that until 2020, and then did it in a sideways way. It's not his fault. This is her fault. This is her delay. This is her wanting to fit a square peg into a round hole, and it's not fair to Chris. It's just not. He has a wife now. He awarded that SPP to his wife. She should not get this at all. Barred by law, for one thing. For another, he complied with your order. He should be given credit for that, Your Honor.
All right, thank you. Anything else, Mr. Willock?
I'm presuming this court doesn't need me to repeat the Henson argument. Mr. Gabata simply misrepresents the law, and the record stands as it is. He also has disregarded the documented history where she did procure an insurance application over 5 years ago, and he blew her off for years, refusing to meet, be examined, or allow for insurance to go into effect. So no, he has produced his own problem, and the problem, by wonderful happenstance, happens to be what's in the best interest of everybody involved. So we have nothing further to say.
All right, with regard to
if I may, just very, very briefly on the counter motion. So an appeal bars the court from making a decision. The appeal has been withdrawn prior to the time when you make a decision. You can make a decision on the motion to set aside. The argument is simple. You satisfy the judgment and should set aside the order and enter another one. We were brief we were very detailed in our briefing. If the court has any further questions of me, I will answer them at this time. Otherwise, I'll stand by our briefing.
All right. With regard to the issues that are pending before me, this case has a long and tortured history, and this court has made numerous determinations and decisions, and the court feels that at every turn it gave the defendant every opportunity to try and comply with court orders until the court was put in the position where it had no other options. I made that finding back at the August hearing, and I said, once I'm without options, then this is the direction we're going to go. But until I don't have options, then I'm going to give him an opportunity. And I felt like that I've bent over backwards, probably to the detriment of plaintiff, based upon the history of this case, what Judge Duckworth has done and what I've done, in order to try and allow him to do it the way that he wanted it to be done. But when we came down to it, he wasn't able to accomplish it, so we moved forward with the order that we moved forward with. Now, I think that we're way past the Henson argument at this point. I think that issue is done in res judicata, so I'm not inclined to take another look at that. As far as what's in the original motion to strike a couple of pleadings, the reality is the court has already reviewed those pleadings, and while the argument is that it could be argument, and the titles don't necessarily reflect the information that's contained within those two pleadings. My preference is to leave it as part of the potential record in case anybody has to come back and review as to what happened, mainly because I have reviewed it, and I considered it as argument, just like I do with everything else that the court reviews, including the supplemental chart that was filed, I think it was yesterday, to take a look at where we are. So since I've considered it and I am the finder of fact, notwithstanding the arguments, and I think they're valid arguments with regard to procedure and what should or should not be included under the rules, I'm not going to strike any of those pleadings or papers that have been submitted to the court and the court has reviewed. And I'm not going to strike the portions of the OID with regard to the survivor benefits because of the several orders I've made in the past and every opportunity that I believe that I gave to the defendant to take another path that just wasn't taken. And it's probably appropriate to note at this point it may or may not be outside of his control at the last minute, but certainly since Judge Duckworth put his order in place 5 years ago, there was plenty of time to make that happen. I gave him 30 days in the July 8th hearing to make it happen. It didn't happen then. I gave additional time all the way up until the deadline. So I feel like that I've given that I did give the defendant every opportunity to do something different. As far as the request for attorney's fees, I have deferred in the past. I deferred back in July. The hope was that we would be able to avoid that by compliance and resolution. We were not able to avoid that, so I think under 18010, I do need to award fees to the plaintiff in this case based upon what's happened to this point. I am going to require an affidavit of fees and costs and a Brunzel affidavit, and certainly, Mr. Gabato, I'm going to give you an opportunity to respond to that request for fees before the court enters that attorney's fees order. I believe that's what I had before me today, unless counsel's aware of something that I've left out.
Nothing further, Your Honor.
Mr. Gabato?
Just for point of clarification, Your Honor, since this is going to end up in another appeal, the court's order was clear that he cooperate, and that if he cooperates, not if it's obtained, that if he cooperates and makes efforts at cooperating, two things will happen. First, you'll allow the SBP to stay with his wife, and second, attorney's fees will not be awarded because you were hanging that over his head. So even though we went over and above in terms of cooperation, not enough? Or is it the court's position that what you're saying now is that he should have actually obtained it rather than made an effort to cooperate? Because the written order, the way that the order is written, says that he has to make an effort and cooperate. Not that it actually have to happen.
All right, and I'm happy to clarify that for you, Mr. Gabato. That was my order in July, that he needed to cooperate. And I presume that that would take place. And that's when I said that I deferred the request for fees and hoping that he'll cooperate and avoid those fees. And then we came back on August 27th. And at that point, we had to take a different tact because we were running out of time. We spent a lot of time discussing options, and we were going to get to a point where we could not make the plaintiff whole based upon those actions. So I would agree that the July hearing talked about cooperation. The August hearing talked about action rather than cooperation. So we clarified it at that point, and again, I was left with no option. If I didn't sign that order at that point, then the way that it was explained to me and not explained any different was that we would never be able to go back and fix it. So that was what I put in my order from the August 27th hearing, which is why I signed the order that I signed, allowing that to take place. So I understand your argument. I believe I've made findings over the last several hearings which makes clear what my thought process was and the reason that I entered those orders. And certainly you have the right to appeal these orders to get some direction from the appellate court on that. But again, I believe that I was left with no options, and if I didn't take the option that I did, that the potential for the plaintiff being permanently harmed as a result of that decision would have been the result. And I think I made those findings getting us to that point. So hopefully that clarifies.
One last point of clarification, if you just bear with me, Your Honor. So the finding is that from the first hearing to this last hearing in August, is the finding that he actually cooperated? Are you finding that he actually cooperated in that period of time?
I'm not finding that he cooperated, no.
Okay. And then in the August 27th hearing, you specifically said after my inquiry that if he obtained insurance by September 1, actually obtained insurance, then the plaintiff can keep this, that he could keep the SPP for his wife. That's what the court ordered. That's what actually happened, but the court's now saying that it was put in a difficult position.
No, I don't believe that's what actually happened. That's not the information I was provided before the deadline, no.
What do you mean before the deadline? I'm sorry.
The deadline. We discussed on the August 27th hearing that based upon the representation of when your client will retire, when that deadline was, I made it very clear we had to have that information before the deadline. 2 o'clock was the deadline. I didn't receive information that would tell me that he had insurance. I'm not sure that I have that information today, Mr. Cabato. So
no. The order from October 27th was the deadline was September 1. Obtain life insurance by September 1, and his wife keeps the SPP. That was what this court ordered, Your Honor. That's what the record reflects. And then after the fact, Mr. Willick submitted the OID the very next day under the argument that there's no possible way we're going to be able to get this to DFAS in time to record it and yada yada, and that's why the OID was entered. That's just a point of clarification, Your Honor. I understand your order, and it will
Well,
be
I
appealed.
guess I would disagree with the point of clarification. The record is what it is. There's nothing we can do to change the record at this point. But that is the basis for me doing what I did, because I felt like I was left with no options, and I made that very clear both in the July and the August hearings with regard to what was required or expected.
Very
Alright.
good, Your Honor. We'll
May I-
prepare
may I
and
make a
thank you for
comment,
your
sir?
time.
Thank you. I'm sorry, Mr. Gavato?
Your Honor, may I make a comment?
Not if you're represented by counsel.
Chris, don't stop. I'll talk to you later, Chris. Thank you, Your Honor.